Okay. Thanks for joining. I request all of you to please stay on mute. We will be starting the session shortly. Harshita, we can have the first slide on screen, please. Done, Harshita? Okay. Good evening, everyone. A very warm welcome to all of you to today's workshop on settlement agreements in mediation, jointly hosted by YCM and the Collective Council. We are thrilled to have such a dynamic and diverse group of attendees here: law students, mediators, lawyers, and peace builders. We'll just take a couple of minutes to let everyone settle in. Please ensure your Zoom name reflects your full name for attendance purposes. And a gentle reminder, this session is being live streamed on YCM's YouTube as well. Next slide. Yeah. Before we delve into the actual workshop, I just want to announce that in order to get in touch with YCM, you can scan this QR and join the YCM community. In order to get the updates on events and upcoming courses at YCM, it will be helpful for you. YCM team member Swati has dropped the link as well in the chat box. Please take 30 minutes, sorry, 30 seconds to join. For the new joinees, here we request all of you to scan this QR code to join the YCM's WhatsApp community. Okay, moving forward, let's kick off with a quick mood check. In the screen, you will see different emojis. You can see different emojis like a wink, a smiley happy face, a sad face. So go ahead and tell us how you're feeling using one word, like one emoji. We'll give you 30 seconds. Please be interactive. We will announce the benefits of being interactive later. So, yeah, I'll give you 30 seconds. Use your chat box. Type out your expressions. Okay, I can see Gaurav Sampath with a happy face. Girish with a happy face. I request all of you in the background and YCM volunteers to unmute, to mute the people who are speaking in the background. Can see a lot of happy faces. Thank you for showing your enthusiasm. Let's wait for 30 more seconds. Let people react.
No, sir.
Okay. Thank you for sharing those vibes, everyone. And with that, here's a quick overview. Can we have the next slide, Harshita? Yes. Here's a quick overview of what's coming up in the next 90 minutes. A keynote session by Dr. Aman Hingorani, which covers basics of drafting settlement agreement, practical techniques and Q&A, a live role play with a mediator's hat activity, career insights and few surprises along the way. Quick note, we'll be picking top 3 star performers based on the engagement today, and yes, a special surprise awaits them at the end. So stay tuned and stay active throughout the entire session. It's now my honor to introduce our speaker for this evening, Dr. Aman Hingorani, sir. Dr. Hingorani is a senior advocate at the Supreme Court of India, an experienced mediator, arbitrator, academic, and author. His diverse contributions to law, dispute resolution, and public policy make him one of the most respected figures in this space. We will have Aman Hingorani as a key speaker for today's session. And now, before we move ahead, let's lighten things up on two quick icebreaker questions. You can respond to the poll. Do you think the mediator should actively help parties draft the settlement terms or simply act as a passive recorder of what the parties say? If you feel yes, you can choose any of these options. We'll have 30 seconds for this poll. I request all of you to actively take part in this poll activity. Okay, now let's share the results. 72% of the audience said yes, and 16% audience said no, and 12% of the audience said maybe. That's an interesting mix. And let's have the next poll question. Harshita, you can trigger this poll question. Do you believe that the language used in a settlement agreement can shape or even sabotage the implementation of a mediated outcome? If yes, You can choose yes, no, or maybe. We'll give you 30 seconds to answer this poll. Good. I request every participant in the room to actively take part. Yes. Now we can share the results. 80% of this audience said yes, 14% of the audience said no, and 7% said maybe. It's an interesting mix. Before we delve deeper into the drafting the settlement agreement workshop, just think about your answers. Keep that in mind so that you will know your answers might change towards the end. Okay, next. Before we move ahead, can we have the next slide? Yes, before we move ahead, we have a very special message to share. Kudrat, the founder of YCM, unfortunately couldn't join us live this evening, but she has sent across a short video message for all of us. Her vision, energy, and commitment to building a more empathetic and accessible conflict resolution ecosystem is what led to the creation of YCM and continues to guide everything we do. Let's take a moment to hear from her.
Disagreed with anyone, a friend, a neighbor, a work colleague, the government, or a family member? Have you ever lost your time, your peace of mind, your money, or a relationship in a conflict? Have you ever ignored a conflict, suppressed it, and later seen it blow up into a big dispute? Peace is not the absence of conflict, but the ability to deal with it. Hi, I am Kudrat Dev, the founder of YCM. We are building your ability to say you can resolve it, you can prevent it. YCM is revolutionizing the scene in India and globally in several ways. You can make a choice to change the way you deal with conflicts in 3 ways. 1. Train with us so that next time you face a conflict, you are prepared to deal with it, you're prepared to resolve it, and if you're proactive, you can prevent it. 2. Use our services when you need an expert to assist you to navigate your conflict and to arrive at a solution which is best for you. 3. Join our network, join our force of like-minded people, become a peace ambassador so that you can resolve it, you can prevent it.
Okay. With that, thank you, Kudrat, for always inspiring us with your clarity and compassion. Please come back stronger. Yes, now it's my pleasure to invite someone who has been pillar of support in making today's event possible. Lavanya Gupta is the executive member of the Collective Council, a vibrant and growing community built to empower first generation lawyers and law students across India. Through mentorship, learning spaces, and peer solidarity, the Collective Council is redefining how young professionals access opportunities, navigate the legal world, and support each other. Lavanya, we'd like to hear your reflections and what today's workshop means for the community. Over to you, Lavanya.
Hello, am I audible?
Yes, you are.
Good evening, everyone. It is a real pleasure to be here today representing the Collective Council, a platform built to support, mentor, and uplift the first generation lawyers. Founded by Advocate Yashwardhan Rane, this initiative has always aimed to create meaningful opportunities and accessible mentorship in the legal field. Workshops like this one remind us why practical legal education is so essential. Mediation is no longer just a peripheral skill. It is becoming central to, dispute resolution in both domestic and international context. And having someone like Dr. Aman Hingornari's stature take us through the nuances of settlement agreement is a huge value addition for every young legal mind that is present today. When we began working with YCM on this initiative, we hoped it would, resonate. And to see that over 400 participants are signing up, it just reaffirms that hope. It's always inspiring. And, when this collaboration turns into an impact, and especially glad that people like Swati Saxena ma'am, who first brought this opportunity forward, and the YCM team, who shaped it with such dedication, are part of this growing ecosystem. As the collective council continues to build bridges for learning and growth, I'm happy to see this platform becoming a space where knowledge is generously shared and skills are shaped meaningfully. I'm looking forward to an enriching session ahead. Thank you so much, everyone, for joining.
Thank you, Lavanya, for such a wonderful words, and thank you for taking your time out to engage in our workshop. Thank you once again. With that, Harshita, can we have the slide, please? Yeah. Uh, this opportunity, this workshop that we do is all a part of growth and learning option for all the students and professionals here. So this QR will take you to the page where you can connect with YCM in different forms. You can train us, you can connect, and you can become a mediator or negotiator after taking our training. You can join the mediation community. You can, if you're a student, being from a legal and non-legal field, you can connect with YCM and do intern with YCM. You can launch a YCM chapter at your university. You can share your insights, share your thoughts, and become a blogger at YCM. If you have an idea, an email, connect at ycmindia.org with subject line. So, idea for YCM and me. So, this is also important. This form is also important because we consider this form as an attendance sheet for this workshop. So, yeah, the YCM volunteer has also dropped the workshop, the feedback form link in the chat. You can take a minute to fill out this form. For people who have logged in from mobile phone also, you can find the link in the chat box.
Mm. I'm all,
Okay. Yes, Aman sir.
yes. Good
Thanks
evening.
for joining, sir.
Yeah.
Harshita, you can stop sharing. Before we hand it over to you, sir, I would
Mm.
like to introduce you to the audience.
Mhm.
It's my honor to introduce our guest speaker for this evening, Dr. Aman Hingorani, sir. Dr. Hingorani is a senior advocate at the Supreme Court of India, an experienced mediator, arbitrator, academic, and author. His diverse contributions to law, dispute resolution, and public policy make him one of the most respected figures in this space. His book, Unraveling the Kashmir Knot, is widely acclaimed, and he brings the rare blend of legal depth, teaching excellence, and practical wisdom. We are truly privileged to have you with us, Aman sir. Yes, sir. Over to you.
Thank you very much for that very kind introduction. Uh, well, the topic of today is settlement agreements, and I would assume that all the participants would have become familiar with the final stage of mediation, that is drafting, should there be a settlement, to reduce everything in writing in form of an agreement. And it is important that that happens because um, the status of a settlement agreement, I'll explain that a bit more. It is varying under the existing law, but generally speaking, in general terms, a settlement agreement is enforceable as if it was a decree passed by a court. And so, drafting a settlement agreement itself is a performance skill. Mediation as a whole is a performance skill, but it culminates in the settlement agreement if there is a settlement, and that is a performance skill. And so, for that, it is important to have a few things in mind. A settlement agreement, unlike a judgment or arbitral award, does not talk about the past. It does not give a recital. It does not explain why there was a dispute or how did the dispute come across. How did the dispute arise? It basically talks about the future relationships of the party. So what we normally do is simply say disputes arose, matter was referred to mediation with the consent of the parties. Then through the process of mediation, parties have come to a settlement with their own volition, is voluntary, and these are the terms. So the settlement agreement will contain a statement about the parties' future relationship. We'll talk about responsibility of each party in implementing the particular settlement terms. The settlement agreement, if it's to be executed as a decree of a court, has to be clear, concise, concrete, realistic, workable. It has to be balanced. It should reflect a win-win situation that both sides are getting something out of it. The settlement, the language has to be positive without any blame assessment. It has to be non-judgmental. So that is some, without being exhaustive, some of the features of a settlement agreement. While, of course, law permits parties to circulate drafts of the settlement agreement, from experience, it is better that the mediator drafts a settlement agreement, because the mediator can preempt future disputes. If a party is set drawing up their own settlement agreement, they'll probably use terms. Once put in black and white, then it's very difficult to get rid of those terms, because it can create a trust deficit to the other side. Why is this person using this term? And if I want to get rid of it, what was it? I mean, the terms can become suspect. On the other hand, if the mediator drafts a settlement agreement, the mediator will use the language which protects both sides equally, which is more balanced, which is more fair to both sides. And so, while a party can suggest terms of settlement, it is better, it's preferable that the mediator takes upon himself or herself to draft the settlement agreement. Now, once there's parties have come to a consensus about the terms, before the mediator starts drafting, the mediator should orally summarize the terms, orally recite the terms, clarify any particular point, because it has to be as specific as possible. get the parties to confirm that everybody is on the same page. So while drafting a settlement agreement, the mediator has to be specific, cannot use ambiguous words such as reasonable, soon, frequent, cooperative, practicable. You can't say A will pay B 1 lakh rupees as soon as possible. It means nothing. It has to be closed. A will pay B 1 lakh rupees within a period of 2 weeks from today by means of demand draft or net transfer. Every single the term has to be closed so that there's no ambiguity in that particular term. The settlement agreements must state clearly who will do what, when, where, how, for how long, how much will that person do that particular task or that particular commitment. Each of these aspects must be put out there, closed with in terms of time or place or in what manner that particular action has to be done, complete with default clauses. What are the consequences if a person does not do what they have committed to do? So the default clause is inbuilt. That itself is a deterrent for a person from residing later on or violating the settlement agreement. The settlement agreement must avoid legal jargon. The language has to be plain as possible, preferably the language of the parties. Because at the end of the day, parties take ownership of the settlement agreement. So it has to be their settlement agreement. They have to understand it. It has to be within the parameters of the law. That's where the legal part comes in. And we'll discuss this again because I'm sorry. Is that a question?
पूर्ण माझ्या अंगावर एवढं पाणी ओढलं मला 2 मिनिट काय दिसेना.
May I request everyone to switch off unless you have a question. Would request everyone to put themselves on mute. I'll come to the question. I can see there's a question in the chat box. I'll come to the questions once. I don't plan to speak very long, but I want to make it open up the floor and take as many questions as possible. But I do want to flag few things before we get into the Q&A. So these principles are something which are of general application, but which must be kept in mind, the focus being or the emphasis being that drafting a settlement agreement is a performance skill. It is not as though there's a template or a format which one can just do copy paste. Of course, there's a template for the structure as to parties appointed so on as a mediator. These are the number of sessions. The parties have arrived at settlement freely with their own volition, without coercion, etc. But the term, for those terms 1, 2, 3, 4, there's no template. That's where the skill comes in for drafting a settlement agreement. Now, the parties will sign on every page. The council, the practice in India, at least, that the council signs on the last page. If there's no council, then of course, whoever that requirement is not there, the mediator would authenticate that particular settlement agreement, furnish a copy to the parties, and then the role of the mediator comes to an end. Mediator no longer has a mandate to do anything beyond that. Now, when we come to India in particular, what is striking is that there is a varying status of the settlement agreement. For many, many, many years, many decades, in fact, India has struggled with trying to draw a distinction between mediation and conciliation. Whereas in most countries, and now with the Singapore Convention, they are synonymous. They're the same thing. But our Section 89 used conciliation and mediation as though they were separate terms, and you had an arbitration, and you still have the Arbitration Conciliation Act of 1996. You have the Mediation Act, which has been there, which have been passed. Some of that sections have been notified. The rest have yet to come to operation. But once the Mediation Act comes into operation, the Mediation Act will subsume the Conciliation Act. So whenever we talk about conciliation, we're actually talking about mediation. Mediation and conciliation are basically the same thing. They've been used interchangeably all over the world. The Supreme Court had tried to draw distinctions in Salem Bar Association, but in Afghan's judgment in 2010, the Supreme Court itself held that mediation and conciliation are the same thing. They use the synonyms. So we go on that footing. As far as the Conciliation Act is concerned, the status and effect of a settlement agreement of a conciliated agreement, this in conciliation, when we still have the distinction between mediation and conciliation. As far as conciliation is concerned, the settlement is going to have the same status and effect as if it is an arbitral award on consent terms. So it is enforceable as though it's a decree of a court. But a mediated settlement agreement would be at best like a contract that needs to be specifically enforced. A court-annexed mediation settlement agreement would be, according to the existing law, would be like a compromise application under Order 23, where parties would then have to give a statement before the referring court, which will pass the decree, and then that decree is enforceable. So the same process, same parties, same third neutral party, mediator or conciliator, same outcome, but a different status depending on whether it is a conciliation or a mediation, whether it is private or whether it is court annexed. Now, this unfortunate situation has been carried forward in the Mediation Act. The Mediation Act in Section 57, which is a transitory provision, says the Act will not apply to court annexed mediations. So that continues. And this is transitory till the authorities make the rules under Section 15, Clause 1 of the Mediation Act. So no rules have yet been made. So the Mediation Act, as of date, excludes court annexed mediation till the rules have been made. The Mediation Act in Section 26 says that this Act, the provisions of the Mediation Act, will not apply to proceedings before the local adalats or permanent local adalats under the Legal Service Authorities Act. So they have been excluded. So what this Act essentially covers at the moment is private mediation, whether individual or institutional. As far as private mediation is concerned, you have provisions in Section 19, 20. Section 19, if we simply glance of the Mediation Act, it talks about the Mediation Act, including agreement in writing between some or all of the parties, settling some or all the disputes. So there can be a partial settlement. There could be disputes which have been brought in with the consent of the parties. And it will also include online mediation, which is yet another area, because online mediation in the Act only talks about online in context of a virtual mediation. Mediation in a virtual setting, not in context of smart contracts, where a mediator may be given access to the blockchain to code in a settlement agreement, and there can be an automated enforcement. Those concepts, because we're still struggling with virtual currency, we're still struggling with smart contracts being legally enforceable in India, because the signatures on a contract for it to be admissible in India has to be those recognized under the IT Act, not the hash key of a smart contract. So there are many other issues that you won't get in right now. But the Section 19 says a media settlement agreement will include a settlement agreement resulting from online mediation. Section 20 gives an option to register a mediated settlement agreement. Of course, it excludes the court annexed mediated settlement agreement and those before the loc adalats. But otherwise, there's an option to register the settlement agreement, though that has no implications on the enforceability. That's only for the point of view of creating a record. And the timeline has been given, etc. And as a departure from the Conciliation Act, we have provisions in the Mediation Act which talks about enforcement of mediated settlement agreements It says, of course, will be enforceable as though as the decree passed by a civil court. That's in section 27. But section 28 is interesting. It contemplates a challenge to a mediated settlement agreement. And that can be on the grounds of fraud, corruption, impersonation, or where mediation was conducted in a dispute of matters not fit for mediation under section 6. Now, corruption, fraud, corruption, impersonation are basically, I would say, all get subsumed in fraud. They're the same genus. If somebody is doing impersonation, it is fraudulent. And then the other categories where mediation was conducted in disputes of matters not fit for mediation. When it comes to a challenge, the Act says that the application should not be made after 90 days from the time of receipt of a settlement agreement, not from the time of discovery of fraud, but from the time of receipt of a settlement agreement. And that's very unusual because fraud vitiates everything. Fraud unravels everything. You can't really put a time limit or limitation. But even if you have to, it has to be from the date of discovery of fraud, not from the date of receiving a certified copy of the settlement agreement. So there's something basically wrong out there. 90 days from that, extendable by another 90 days. So if I discover fraud, say after 180 days, I can't challenge the settlement agreement. So that is something which is quite startling. As regards mediations conducted in disputes or matters not fit for mediation under Section 6, Section 6 basically says there are certain matters which are not fit for mediation. And the list of those matters are in Schedule 1 to the Act. Those schedule includes matters like criminal matters. So no criminal matter can go for mediation. There's a long list of matters which are there in Schedule 1. So if you think about it, you have a situation where mediation has been, by the Mediation Act, this Mediation Act has been made applicable primarily to private mediation. That too, to matters which are not on the Schedule 1. And that too, as we see when we talk about some other provisions like Section 43, when we talk about community mediation, there's yet another departure. For community mediation, the provision is that a settlement agreement pursuant to community mediation will not be enforceable as a decree of a court. So there seems to be no coherence in the Act itself as to when you can enforce, when you cannot enforce. Now, to make the matter worse, the Act attaches some schedules. So you have Schedule 7 to Schedule 10, which are relevant. Schedule 7 basically says, each of the schedule refers to different acts. When it comes to Schedule 7, it refers to the Micro, Small and Medium Enterprises Development Act 2006. Here they say that the conduct of mediation will be as per the Mediation Act. But when it comes to 8th Schedule, Companies Act, the settlement agreement has to be sent before the referring tribunal, who will then pass an order to make that settlement agreement a decree of a court. So varying treatment, whether you're under the MSME Act or whether you're under the Companies Act. Again, when you come to Commercial Courts Act, it says that is Section 9 Schedule, pre-litigation mediation settlement. It will be as per the Mediation Act. But when we see the 10th Schedule, when you come to the Consumer Protection Act, again, the settlement agreement will have to be sent to the Consumer Court, who will then pass an order. And it is only after that order is passed is enforceable as a decree of a court. So, in my view, there's complete incoherence in the Mediation Act as to the status and enforceability of a settlement agreement within the Act itself. As I mentioned, we're excluding court-annexed mediation from this particular Act for the time being is a transitory provision. So we go back to the existing provision. Existing provisions have been spelled out by the Supreme Court in AFCON's judgment, which basically the thumb rule is if a mediation, if a dispute has been referred to mediation by a court, whether to a court annexed mediation center or to the authorities under the Legal Service Authorities Act, and there's a settlement. That settlement is not a decree of a court. It has to come back to the referring court to be disposed of. On the other hand, if there's a pre-trial litigation directly before the mediation center, or there's a Lok Adalat award without a reference to a court, then that's a decree of a court. So we're perpetuating this thing under this act. So in my view, we need to have more clarity and more, I mean, there has to be, someone has to actually amend or streamline these provisions, statutory provisions, because this is going to be a source of conflict. There'll be, rather than resolving conflict, we'll be creating more and more collateral challenges, because the status and enforceability of a settlement agreement itself is mirrored in controversy. The final point before we open up is the issue of ethical standards. Now, mediation is a practice of law, but it's not only a practice of law. Anybody can be a mediator. You can have a non-legal person being a mediator. And even otherwise, when you're a mediator, when they are doing mediation, if you talk about breaking the conflict cycle, getting to the mind of a party, trying to understand behavioral sciences, trying to get the parties to confide, overcome communication inhibitors, do reality testing, have your shifting gears between joint and private sessions. When you're trying to do restorative justice practices, you're trying to handle emotions, you're doing something much more than what a lawyer does. If that is the case, then what are the ethical rules for accountability of the mediator? What if the mediator is not addressing power imbalance and is recording a term in the settlement agreement deliberately to favor one side? How do you make the mediators accountable or responsible in the discharge of their function? They have to be ethical standard, but it's a multidisciplinary profession. Do we bring in rules of Bar Council of India? Do we bring in rules of different other statutory bodies? If there's an architect who's a mediator, if there's an engineer who's a mediator, what rules will apply? In India, we yet to have that debate on ethical standards of mediators. We have certain standards which were considered by the Supreme Court in Selim Bar's case, which are reflected in the High Court rules in most high courts. But in my view, they are wholly inadequate because they do not cater to a situation where mediation is something more than a practice of law. So these are few thoughts on settlement agreements. I'll be happy now to take questions from the audience. I can see we have certain questions out here. But how would you like to go through this? Ashita, would you like to take it, or who would be comparing the questions?
Okay, thank you. Thank you so much, sir, for this incredibly insightful and thought-provoking session. To bring in more clarity and depth, we have curated some questions. And before I open the stage for the audience, I would like to ask those questions. And meanwhile, I would request the audience to put in their questions in the chat box so that we can take up from there, if that's okay.
Okay. So in the chat, I can see Dave has put in some questions about UK, where they say that the meter will not draft the settlement agreement. It's left to the lawyer to draft. Those advised to check what has been drafted. In UK, the mediator does not usually authenticate or sign the settlement agreement, does not have a Mediation Act or Conciliation Act. And in India, it's actually quite the reverse. The Conciliation Act requires or suggests that the mediator or the conciliator actually should draft a settlement agreement and circulate to the parties. And there is case law for the proposition that even if there's a settlement agreement, but if that is not authenticated by the conciliator, it's not a valid settlement agreement. So the requirements of law in India are quite distinct from the practice and the legal position in the UK. The second question is, and if in the UK the legal proceedings are afoot and settlement is entered, one party notified does not provide a court. As again, as far as if there is a settlement which arrived at between the parties during court proceedings, then the procedure in India, the provision of the Civil Procedure Code, as far as India is concerned, is to file a compromise application before the court, on which the statements of the parties will be recorded, and then the court passes a decree in terms of the compromise application, that decree is then enforceable before the executive court if there is a default. Of course, if it is open for the plaintiff or the petitioner to tell the court, I do not want to press my case since I have had an out-of-court settlement. In that case, the case will be simply withdrawn. But more often than not, parties, should there be a settlement, prefer to route it through the court so as to at least keep the terms, give sanctity to those terms in terms of a court decree, as opposed to a settlement out of court, which would then need to be specifically enforced in case of a violation. In UK, there's no concept of matter not being suitable for mediation for parties to decide. In India, in AFCON judgment, in Salem Bar, and of course now Mediation Act, there have been a whole line or list of items which have been found to be not suitable for mediation. And if we see Schedule 1, just to give a flavor of the kind of matters which talks about disputes relating to claims against minors, deities, persons with intellectual disabilities, and so on and so forth, dispute involving prosecution of criminal offences, complaints of proceedings initiated before a statutory body, if that is for professional misconduct, etc. Disputes which fall before the National Green Tribunal, that is for the environmental issues, certain issues out there, any proceedings relating to collection, levy of penalties, offences, taxes, proceeding under the Competition Act, and so on before the SEBI, land acquisition, the whole list of items which have been identified as not being fit for mediation. It is again controversial, more so when you have when you put all criminal cases in, regardless of the severity of the criminal offense. So if it's a municipal offense, check bouncing, electricity theft, there's no reason why that can't be referred to mediation. Rape, dacoity, murder, terrorism would not be referred to mediation. So that kind of distinction had been made earlier, but this act simply says all cases of a criminal nature cannot go for mediation. And it actually has a big impact for one kind of mediation, which is very prevalent in matrimonial law, that is 498A, which is non-compoundable. That's for dowry, treating women for cruelty, endangering a life, and also related to dowry. Section 6 says that when it comes to matrimonial offences, you can only refer compoundable matrimonial offences for mediation, not non-compoundable, but the most common one is non-compoundable. And according to the Section 6 of the Mediation Act, that if you refer a matter to mediation and that dispute relates to one of those items listed in Schedule 1, then that the settlement agreement will not be considered to be a judgment or a decree of a court. So in India, unlike the UK, you have a clear-cut distinction, right or wrong, controversial, debatable, as it may be, but there is that list out there. Now, how is the concept of mediation different from arbitration? Now, mediation, as we know, is a voluntary process, party-centered, non-binding, structured process by which the third neutral party uses their communication, negotiations, facilitator skills to facilitate a settlement between the parties themselves. The parties decide. There's no decision. It's a settlement arrived at by the parties themselves, and that decision becomes binding. So while the process is non-binding, the decision is binding, And since it's a settlement, it basically there'll be a settlement if both parties are gaining something from it. And so it's a win-win situation. Both sides go back happy. They got something out of it. Their underlying interests have been addressed. Arbitration is more adversarial. The arbitrator may not be strictly bound by rules of evidence or the procedure, but the arbitrator still has to follow the adversarial mode of getting the parties to give the statement of claim, give the reply or written statement to the statement of claim. Unless parties say we want to have the matter decided only on pleadings and pleadings only arbitration, otherwise evidence will be led. And then what comes out is a decision by the arbitrator. The judge gives a judgment, and arbitrator gives an arbitral award. One party wins, one party loses. So arbitration is adversarial, mediation is non-adversarial. It's not that they are, of course, in arbitration also, parties can be encouraged to go in for mediation or conciliation and have a consent award. But arbitration is, while both arbitration and mediation are known as ADR, alternative to the formal legal system, nowadays people view ADR to be appropriate dispute resolution. Certain cases are better resolved through courts, like constitutional matters or cases of heinous offenses. Certain cases are better resolved through arbitration, but certain cases are better resolved through mediation. So they all complement each other. They may be outside the formal legal system, arbitration, mediation, but they're just as integral to it. It's alongside the formal legal system. Fine. So now, again, the question from Dave about a mediator be called for give evidence. No, whatever happens in mediation stays in mediation. Confidentiality is at several levels. A mediator cannot be a counsel, cannot be an arbitrator, cannot represent a party. A mediator cannot be called for a witness. What happens in mediation the court can't ask what transpired in mediation. Of course, exceptions have been carved out now. For example, in cases of child guardianship matters, or where there is a professional misconduct or threat to commit a crime, etc. But otherwise, you cannot ask what happened in mediation. Communication between the court and the mediators confined only to whether there's settlement, if so, the terms, or whether there is no settlement. A mediator cannot be compelled to disclose what has happened. There cannot be any audio-video recording of what happens in mediation. Nor the parties cannot lead evidence as to what transpired in mediation. So their confidentiality at several levels. So the mediator cannot be asked to give evidence by the court. Of course, in Perry Consagra case, the Supreme Court said that when it comes to guardianship matters, we must have information from all sources. So if there's a mediation relating to a child, where a child is involved, the mediator can communicate what has happened, but then those are limited cases. Again, controversial. Mediation is not a discovery process. The guardian court should find its own material to decide. If a mediator has to break the conflict cycle, lower down the defenses of a party, get into the mind of the party to understand where the party is going wrong, and suggest how things can be done differently, that can happen only under the cloak of confidentiality. No party will come for mediation and disclose whatever's happened if they feel whatever they tell the mediator will find their way to the court, who will then decide that case based on that information. So it is an antithesis to mediation to communicate to a court what transpires in mediation. I can see in the hand up of Dave. We'll come back to you in a minute. Let me just see the other questions. Personal law is suitable for mediation. Well, in India, personal law travels to the person. So whether it's in terms of succession, divorce, everything relating to matrimonial law, family laws, all these are cases which arise in personal law, and they are suitable for mediation, because wherever there's a case of emotional component or where you have a feeling, where you have a situation where law maybe is like a bull in a china shop, is going to create more damage than anything else, their mediation is suitable because people can rank their underlying interest and go back with their underlying interest satisfied so that they're more at peace with each other. So cases relating to personal law within personal law can, of course, be referred to mediation. What are essential elements to make it binding? I've already talked about that, that it must be the settlement agreement. The mediator is not concerned with the fairness of the settlement agreement, but the mediator must be show that the terms fall within the parameters of the law. If the settlement agreement relates to a term which is not enforceable or against public policy or which is void otherwise, then it is not going to be enforceable. So the mediator must know the applicable law and have the settlement agreement within the parameters of the law. Terms have to be decided by the parties. And I've already talked about how to make the mediation settlement agreement as concrete, realistic, workable, executable as possible. Whether mediation rules, regulations have been notified, the rules not, they've set up, they've notified the provisions for setting up the mediation council, but to at least to the best of my knowledge, nothing has yet been notified, the rules have not really been notified. So that's the reason why we are still following the Conciliation Act and the mediation rules, which were considered in the Salem Bar, incorporated by different high courts. All this will be subsumed once you have the Mediation Act, once it's been fully implemented. India signed the Singapore Convention. As far as the Singapore Convention is concerned, the whole debate was to have a law in conformity with the Singapore Convention. This law, according to me, does not, because this law says a mediated settlement agreement will have a status of a decree of a court. But if you see the Singapore Convention, that actually says that the convention will not be applicable to settlement agreements that are enforceable as a judgment in the state of that country, or settlement agreements have been recorded or enforceable as an arbitral award. More so, there is a lot of controversy about to what extent Singapore Convention is only for commercial settlement agreements, on the issue of the opt-in, opt-out, on the issue of what is against public policy. All those things have yet to be tested, but that is only going to happen should India ratify Singapore Convention. But before that, we have to have a domestic law, which is in conformity with the principles of Singapore Convention. Yes, Dave, I think I can see your hand raised. Please, you have a question, you can, or you have a comment, please, you can unmute yourself. Yeah.
Yes, thank you. Firstly, I'd like to apologise for explaining the differences with what happens in the UK, particularly as we haven't got a Mediation Act. I just wanted to raise the question of confidentiality after the mediation, because there's a case in the UK a few years ago now where one party alleged financial duress during the mediation and wanted to call the mediator to substantiate that. The court decided that it did have the power to require the mediator to attend and give a verdict or comment about what happened during the mediation. It didn't actually transpire because the parties subsequently settled at another informal agreement, which was implemented. Do you think, and that was held as a matter of policy, that if there was financial duress or an allegation of it, that as a matter of policy that should be investigated by the court? Do you think that in India the same kind of philosophy would apply?
Well, as far as the existing law is concerned, the provisions are that you can't really call a mediator to disclose or be a witness, or even in the circumstances you talk about, the settlement agreement has the status of a consent decree. And so for that reason, the grounds on which a consent decree can be challenged, that it was fraud, etc., then if the burden is on the person to prove it by going in appeal. But that would not entail a mediator coming and giving evidence. But the Mediation Act, which is yet to be fully notified, does cater to such a situation. You have in Section 22 the confidentiality provisions we talked about at different levels, but you have in Section 23 which says, I mean, I can read it. I have this act before me, so I can read it out. No mediator or participant in mediation, including experts and advisors engaged for the purpose of mediation and persons involved in the administration of mediation, shall at any time be permitted or compelled to disclose to any court or tribunal or in any adjudicatory proceedings by whatever description any communication mediation, or to state the contents or conditions of any document or nature of or conduct of parties during mediation, including content of negotiations or offers or counter offers with which they become acquainted during mediation, provided that nothing in this section and the confidentiality provision, section 22, shall protect from disclosure information sought or provided to prove or dispute a claim or complaint of professional misconduct of mediator or malpractice based on conduct occurring during the mediation. There shall be no privilege or confidentiality that will attach to a threat or statement or plan to commit an offense punishable under any law for a time being in force, information relating to domestic violence or child abuse, statements made during mediation showing a significant imminent threat of public health or safety. Now, this is exception which is sought to be carved out. Again, a controversial one, because and this is confined more to the professional misconduct of the mediator during the course of mediation. Now, should a mediator be misconducting himself or herself, that's a ground for terminating the mediation there and then. That can't be a ground for waiving confidentiality. Of course, there's no confidentiality for a threat of client to commit an offense. That is still understandable. But when it comes to information relating to domestic violence or child abuse, in India, domestic violence has been defined to be so wide that economic deprivation, any kind of trauma comes in domestic violence. If we do not have confidentiality attached to these kind of matters, you can rule out mediation in matrimonial law, which is the bulk of the mediation that's happening in India. So no one is going to come and start talking to a mediator about what has happened within the privy of the home without that cloak of confidentiality. And of course, if there's a statement made during a mediation showing a significant imminent threat of public health or safety, terminate the mediation there and then. So the grounds which have been given under the Mediation Act to waive off confidentiality or privilege actually are grounds for terminating the mediation as opposed to waiving of confidentiality. So if there's a financial duress by any kind of duress, I would say, at the instance of the mediator during the course of mediation, that is a ground for terminating the mediation and making a lodging a complaint against the mediator. If there's been duress by either party, etc., any kind of duress, or there's a power imbalance, the mediator is supposed to exchange neutrality for removing the power imbalance. Go in a private session, remove that power imbalance. After removing the power imbalance, if a party is still willing to, the party is still willing to settle on a term which may seem to be unfair to the mediator or unable to mediator, but the party is choosing to do so, then that's not the domain of the mediator to test the reasonableness or the fairness. Mediators to assure the fair process. The fairness is that left for the party. And once the party chooses to take a call on the particular term, even if it's unfair, after removal of the duress or that kind of irrationality, then the mediator has to simply go ahead and record the settlement agreement.
Thank you very much. Thank you.
Any other question? I think we have come to the end of all the questions.
Yes, I guess so, sir. And also due to time constraints, we'll stop here. And I would like to thank you again. I think much of our doubts are cleared now, and we have gained so much from your responses to the wonderful questions the audience has asked. Um, Now, I have a small request to make. We would like to take a picture with you, sir, and all the participants who are here. So, I would request everybody to switch on their cameras so that we can have a good picture with sir.
Chita, if you're ready, you can say thumbs up, you're on mute, and we can take a picture with the audience as well. Thank you,
Yeah.
audience, for your prompt response.
Thank you.
If everyone could give a thumbs up, it would be lovely.
Thank you.
Okay, we go 3, 2, 1. Okay, perfect.
Okay. Thank you, Aman sir, once again.
Thank you all.
Great meeting.
Have a
Thank
good
you.
night.
Thank you. Thank
Yeah.
Thank you, sir.
Participants, please don't leave the meeting. We have another important session, that is a mediator's role play and a activity, which is coming up next. I want the YCM volunteer to pin the actors. So now we move into a dynamic and hands-on segment, as I mentioned earlier, where you will not only watch a mediation unfold, but also learn the key elements of a strong settlement agreement and get to step into the mediator's role you yourself. So we'll begin with a 3 to 4 minute live role play of landlord and a tenant dispute. Mr. Kumar, the landlord, and Sanya, the tenant, are in a dispute. Sanya was supposed to vacate the apartment on 31st May. Mr. Kumar agreed to refund 50,000 as the security deposit once she moved out and handed back the keys. However, during the mediation, they only wrote Mr. Kumar agrees to return the security deposit after Sanya vacates in the settlement agreement without specifying the date, the condition of the property, or timelines of the refund. So, I'd like to welcome the actors for this role play. Mr. Subhash Deshpande, who is a YCM trained mediator and who is going to play the role of the landlord, and Miss Meera, who is also a YCM trained mediator, who is going to play the role of a tenant, Sanya. I'd also like to welcome Bhavin, who is going to play the role of a mediator, who is also an actually YCM's IMI certified mediation course person who had done it. Yeah. Over to you guys.
So good evening, both the parties. Thank you both for attending today. I am Bhavin, here as your mediator. My role is to facilitate and help you come to a clear and a workable settlement. So, Mr. Kumar and Ms. Sanya, would you like to briefly confirm what you agreed so far?
Yes. Sanya will vacate the flat and I will return the deposit 50,000 rupees.
That is completely right, Mr. Bhavin. But here, Kumar uncle, I would like to point out that I want it in writing that I'll receive the refund money as soon as I vacate the flat.
Yeah, that's a good point, Sanya. So let's make sure that we talk this out clearly. Mr. Kumar, when will you return the deposit? Can we specify a timeline or a time period?
I was thinking of some time after she vacates the flat.
Sanya, when are you planning to vacate the flat?
So, as considering today to be July 2nd, anytime around July 5th, I'll be vacating the flat, given that I know that he'll return the deposit.
Okay. So how about we say Mr. Kumar agrees to refund the amount of rupees 50,000 deposit within 7 working days after Sanya vacates and hands over the keys to Mr. Kumar. Does that work for both of you?
That's clear for
Yes.
Okay, great. So let me put this into a draft settlement so we don't leave any room for any confusion. So Miss Sanya will vacate the room on July 5th, that is 3 days from today, and Mr. Kumar within 7 working days from July 5th will return the deposit of rupees 50,000 via bank. Is that okay, both of you? Can we proceed to the draft settlement?
Yes.
Yes, works for me too.
Okay. So it's finalized. Thank you both for your patience and cooperation. Thank you.
Thank you so much, Mr. Mediator.
Thank you, Mr. Mediator.
Okay, let's give a big round of applause to the actors Bhavin, Mr. Kumar, and Miss Sania. So, with that, I would also like to hand over to the actors to share their journey as a mediator post doing a YCM's IMI certified mediation training. Over to you, Sania, who is actually Meera.
Hello, everyone. I hope you're enjoying the session so far. So, I've been in the December January cohort learning a mediation course. So, when I first joined mediation with YCM, it was completely with no expectations, but it stood out for me. The journey I had and the experience I had was really amazing. The diversity of people we met during the course made us learn from each other more than what we've been learning, and also along with an amazing professional course as well. YCM provides a platform for individuals of all ages and professions, making it unique in its own way. I joined mediation program without much expectations, as I said. So Faiza ma'am, who was our course coordinator, who is also here with us today, made the experience so good, and now I can proudly call myself to be a certified and trained mediator being in my first year of college. So thanks to YCM and Pfizer ma'am as well.
Thank you, Meera, for the wonderful words. I'd like to, you can pass it to the other two co-actors.
Okay, I pass it to Bhavin, who played mediator. He was also in the same cohort.
Yeah. So I'll take this moment to say a heartfelt thanks to the YCM team members, the trainers, the mentors, and my fellow participants. So the training month was an incredible journey. I met many new people. This mediation course didn't just teach me techniques; it helped me find my voice. See, I had this fear or stuff. So initial stage of the course, I was fine playing the party side, but later stage, Faiza ma'am and the other mentors, they trained us, gave us skill trainings, which later made my stage fear go, and hence I'm here playing as mediator so freely and easily. All thanks goes to our YCM team, and I had a very good cohort fellow participants who were very friendly, and I got a lifetime friendship with them. I still have contact with them. It was nice. Thank you all. I pass it
Great.
to
Yeah.
Mr. Kumar. That is Subhas Deshpande.
Hello, everybody. I am Subhash Deshpande. I am an advocate, Bombay High Court, and I am an arbitrator and YCM IMI certified mediator and an expert negotiator. According to me, mediation is a win-win deal for the society, economy, general public, and the litigants. It's a quick and cost-effective way to resolve the issues, disputes, while maintaining good relationships between the concerned parties. Mediation emphasizes on confidentiality, neutrality, trust building activities, and good communication to reach common grounds. It's a process promoting cordial relationships and useful all over the world. And I am thankful to YCM Media for allowing me to learn the mediation in the batch of January, February 2025. Thank you, everybody.
Thank you, Subhashji. Thank you for your wonderful words. With that note, We are now, can we have these slides, Harshita? Let's quickly delve into the activity. It's a very fun activity. If you have keenly observed the whole mediation session, we will have the upcoming scenarios based on that. And most importantly, you are now, every participant here in the room are going to wear the mediator's hat and answer the following questions. Next slide. So please observe the following case. Mr. Kumar, the landlord, and Sanya, the tenant, agreed in mediation that Sanya would vacate the premises after the school exams end, and Mr. Kumar would refund 50,000 as security deposit in a reasonable time after vacating. The settlement agreement recorded the same language. Question: as a mediator, what concern do you see with the way the settlement agreement was drafted? A. The refund amount may not reflect current real estate emotions or economics. B. The time flies and conditions are vague. Timelines and conditions are vague. C. Mr. Kumar is the school principal, so he knows when the exams end. D. The school exams might postpone. You can put the responses in the chat box like A, B, C, D. I'll give you 30 seconds. You can type out the responses. Okay. You can see the responses coming in. Reflect, think, and answer. Okay. I would request the audience to volunteer. You can raise your hand and explain why you choose the particular option. You can click raise your hand option and you can volunteer. Anybody from the audience? Okay. Aparna Singh. Aparna Singh, you can unmute and explain what option you chose and why. Yes, Aparna. You're not audible to us. You can speak. Voice is not clear for us, Aparna. Okay, you can type out the responses in the chat box. Jinnaram Sneha, you can go ahead. Jinnaram Sneha, please unmute and speak. Yes. What option you chose and why you chose?
Hello, ma'am. Choose the option B, where the timelines and the conditions are unclear because Sanya told that she vacated the premises after the school exams and the date was not specifically mentioned here.
Good. Okay. Right answer. So let's debrief it. Next slide, Harshita. So the correct answer is, as a mediator, what concern do you see with the way the settlement agreement was drafted? The correct answer is like how Jinnaram Sneha said is answer B. Why? Because the phrase is like after exams in reasonable time or subjective and non-specific leading to disputes during enforcement. Yes. Next slide, please. The next question, again, people who have raised the hands, you can lower it and we'll give you the option. In the same landlord-tenant mediation, Mr. Kumar and Sanya verbally agreed that the deposit refunds terms would remain private. The written agreement, however, only states that the parties agree to respect the sensitivity of the matter with no confidentiality clause. The question to you is, what is most likely to happen if Sanya publicly shares the settlement terms? A. Mr. Kumar can sue immediately because sensitivity is clearly a legal fortress. B. Verbal promises are sacred, especially in court, right? Option C. The vague language will magically cover everything like a legal invisibility cloak. D. The lack of clear confidentiality clause may prevent enforcement. Okay, I can see the answers coming in. Let's keep there 30 seconds. I'd like to ask the volunteers. Anybody? I can see Vedashri hand. Vedashri, if you hear, what option did you choose and why you chose? Vedashri is not. Gaurav? Gaurav Sampath Kumar, you can unmute and explain.
Good evening, ma'am. Am I audible to you?
Yes, you're audible.
Ma'am, so my answer was option D. The lack of clear confidentiality clause may prevent enforcement. This is because even though they have mentioned sensitivity of the matter, there needs to be the mention of confidentiality clause to make this particular agreement much more binding in nature.
Okay, great, good answer. So obviously the answer is D. Let's have the next slide, Harshita. So the appropriate answer is courts rely on written terms. Vague wordings like respect sensitivity is not equivalent to an enforceable confidentiality clause. Good job, Gaurav. With that, we are moving to the next and this final question. Mr. Kumar and Sanya reach a settlement and sign this written agreement drafted by the mediator. Weeks later, Sanya vacates the property, but Mr. Kumar doesn't return the deposit. So, to Sanya's surprise, the agreement contains no clause about what happens if someone breaches it. The question to you is, which of the following is the most appropriate lesson from this case? A. No worries. Courts can read between the lines for vague settlements. B. Once the agreement is signed, the mediator's work is done. Every settlement agreement should include a fallback or breach clause to prevent ambiguity. D. Mediation agreements are just polite suggestions, not enforceable documents. And yes, I can already see answers coming up. Okay, I'd like to request the volunteers, new volunteers who haven't spoken yet. Veda Shri, you can unmute.
Good evening, everyone. I
Yes.
chose option C. Every settlement agreement should include a fallback or breach clause to prevent ambiguity. I feel this option is correct because the terms of the agreement should be very specific and not ambiguous. At the same time, it would, like, since mediation agreements are not enforceable, conciliation agreements are, it would be better that such clauses are mentioned in the agreement.
Good try, Vedashri. Yes, with that, let's have the answer slide, please. Yes, including a clause that outlines next steps or consequences for breach, a deadline, liquidated damages, or return to mediation provides certainty and enforceability. Okay, now can we have the next slide, please? Mediation fundamentals. If you're new to mediations and looking to, learn the basics of mediation, then this mediation course is for you. So we have 30% off on the self-paced mediation course. The original course price is 3,999, but you can avail it at just 2,799. This offer is valid exclusive to the participants of workshop and it's valid until 8th July. You can scan the QR or take a picture of it, and YCM volunteer has already dropped the link here. You can take picture. We'll give you 30 seconds. Next slide, please. And another important and a crucial announcement is we are starting our YCM's July batch. IMI certified mediation course, which is 40 hours mediation course this July from this weekend, which is 5th of July. And the registration for this course for the course is closed yesterday, but we got rave responses and more demands for this course. That's why we are launching the August batch live here in this workshop, and this is not announced publicly. I request all the participants to scan this QR and to register your interest. If people are registering, we will schedule the course in weekends of August. So the YCM volunteer will also drop the QR, the link for the August mediation training. You can just type yes or no. YCM volunteer, have you dropped the link for the August training? Yeah. Okay, fine. You can take 30 seconds to just put yes or no in the responses so that we will get in touch with you based on your interest. And please don't leave. We have the special announcement, which is the 3 top performers that's coming up next. Okay. Yes. Now, again, this is also before we go to the top 3 star performers. I would request all the participants who are present here to fill this form. This is your attendance sheet. I request the volunteer to drop the sheet in the to drop the link in the chat box. Only after filling this, you will get your certificates. I got some queries on certificates. Yes, we will issue the certificate for this workshop, provided you should have filled this attendance sheet. I'll also give 1 minute for this. A special mention to Dave Owen. Dave Owen is a London-based mediator who is also our YCM's expert friend. So he joined this session, and he was also a very active participant. But we are not choosing Dave because he's our senior expert. That's why thank you Dave for joining and acknowledging and adding more value to this webinar by your active questions. Thank you once again. Okay, with that, the most interesting part of the session is the top 3 star performers is Vedashri Gade, Gaurav Sampath Kumar, and Rohit Bhattacharya. So you can just like turn your screens on and wave hi. And most importantly, all 3 of you, please fill the registration feedback form so that we will get in touch with you for the special surprises. Okay, with that note, it's very happy to all of you, like very interactive cohort, very interactive batch. You made this webinar most successful and even more elegant because of your active participation. Every one of you here present here. I take immense pleasure to thank our trainer Aman sir and all the active participants, the team YCM. Until we meet again, do remember you can resolve it. Thank you all. Thank you, Dave. Bye. See you in the upcoming weekends for the training.
Can we all
Bye.
quickly come for a picture again, Faza?
Yeah. Yes. If the participants, if you're not leaving, can you all quickly turn on the camera so that we can take a quick picture with the cohort?
And we request everybody to turn on their cameras. Yes.
Harshita, if you're ready.
Yes, ma'am. If everyone is ready, yeah. Give a thumbs up. 3, 2, 1, go. Okay, perfect. Thank you.
Thank you all. Good show. Bye.
Bye.